Good afternoon. This is Amanda Kay with the National Council of Juvenile and Family Court Judges. Welcome to our webinar on the Family Court Enhancement Project, Reflections from Multnomah County. Before we begin, I'll provide you with a brief overview of the webinar system and how you can interact with today's presenters. Just below the attendees list, you'll see a chat box. Within this window, you'll be able to send messages to the other participants in this webinar. Chat entered in the Everyone tab will be stored and may be posted online as part of the recording of this webinar. To chat, simply type your message into the white field at the bottom of the window and press Enter on your keyboard, or click the button to the right to send it. On the right side of the screen, you will see a list of materials related to today's presentation. To download them, simply select the files you desire and click the Download File button. A new browser window will open, confirming that you wish to download the selected files. Once you confirm, your download will begin. At the conclusion of this webinar, a survey will appear on your screen asking you to provide feedback on how we did today. We encourage you to take the time to complete this survey as it helps us determine how we can improve future webinars. Please remain in the webinar until the survey appears on your screen. The link to the survey is also available on the right side of the screen just above the materials box. To begin today's presentation, I'll introduce my fellow presenters. We have Judge Maureen McKnight, Chief Family Law Judge of the Multnomah County Circuit Court, and Jenny Woodson, who is the Family Court Enhancement Project Coordinator for Multnomah County. To begin, I'm going to provide an introduction to the Family Court Enhancement Project. You may have seen from the webinar flyer, this is a project, a demonstration initiative that's going on at 4 courts across the country. And the purpose is to look at ways to improve outcomes for custody when domestic violence is involved. At the conclusion of the presentation, you should be better able to describe the purpose of the Family Court Enhancement Project, describe the importance of court and community readiness for undertaking this work, and identify steps that can be undertaken for system assessment and improvement in your own jurisdictions. The goal of the Family Court Enhancement Project is to improve the family court response to divorce and parenting cases involving domestic violence, so that resulting parenting arrangements protect the emotional and physical well-being of victimized parents and their children. We know that custody is a problem where domestic violence is present. Different research studies with different criteria have found anywhere from 1/4 to 3/4 of disputed custody cases involve domestic violence. We also know that abusers are twice as likely to seek sole custody, and they are successful in obtaining sole or joint custody over half the time. That's why this project began. It is a joint effort by several national technical assistance providers and funders. These include the Office on Violence Against Women at the U.S. Department of Justice, the Battered Women's Justice Project, the National Institute of Justice, the Center for Court Innovation, and the National Council of Juvenile and Family Court Judges. We at the National Council coordinate the project. The 4 sites were chosen to participate in this initiative include the one we're going to hear about today, Multnomah County and Portland, Oregon. We also previously had a webinar from Hennepin County in Minneapolis, Minnesota. Also the Circuit Court of Cook County, which is Chicago, Illinois, and the Family Court for the state of Delaware. We'll hear from Cook County and Delaware later in this webinar series. Stages of the Family Court Enhancement Project include the initial stages, once the sites were selected, involved holding launch events and gathering a whole ton of information about how the family court operated, gathering stakeholders and starting discussions about how the family court worked, identifying challenges, looking for contributing factors, and also setting priorities. Following the launch event, there was a 4-month planning phase, which involved continuing to collect data, some roundtables and community conversations, and starting to put together work plans and identify activities that the sites would like to implement to try and improve custody outcomes. And then in January of this year, 2015, the implementation phase began. And so we're well into that. The sites are all working extremely hard. The national partners are providing intensive TA, technical assistance, and continuing to gather information as these activities proceed to see how they're doing. Does something need to be adjusted? Perhaps a particular activity didn't work out and we want to try something else. And we'll be doing this for about another year. The program runs through the end of September 2016. And with that, I'm going to go ahead and turn it over to our site, Judge McKnight and Jenny Woodson.
All right, well, welcome everyone. This is Maureen McKnight, and
this is Jenny Woodson.
We sound like a radio show. Before we get to the first slide here, I thought we would talk just a second about why Multnomah County applied for this particular grant. We are a state, a small state, but also a jurisdiction here in Multnomah County, which is where Portland, the biggest city, is, that I think prides itself on its history in working on domestic violence issues and its, the extent of its collaboration. We have pretty good laws. We have a really strong legislative presence on the issue of DV and sort of a brain trust of people who hash out some of the major policy issues. And I think that sort of self-satisfaction has carried over to the bench, where we tend to think that we do a really good job. And I think that in terms of laws about restraining orders in particular, this state has put a lot of attention into making them, making remedies user accessible, the forms, expanding relief to sexual assault, and thinking through the connection with the criminal context. We're less good on the juvenile dependency, you know, and dealing with some of the major policy issues. But we really don't do well, and I think we put aside during the 80s and the 90s and frankly in the early 2000s, are the core issues about making decisions about custody and parenting time. And it was sort of easy to cream off the peripheral pieces that feed into what a domestic violence survivor might encounter in court. But the core issues of what do we actually know, how do we get it, and how are we interacting with survivors and alleged perpetrators in the courtroom that are in a family law context is something we hadn't hit straight on, we didn't confront. So it was really trying to get to the core issues that we applied for this grant, and doing some of the work that was frankly easy to put off for a couple of decades while we expanded authority and really worked around the edges of what family court was doing. So with that backdrop, I think Jenny's going to sort of take us through a little about our court, and then I'll be intersecting or interrupting or adding to, however one wants to look at it.
And I'm, Amanda, I'm pressing next, and it doesn't seem to be, oh, there it goes, wrong button. So just a little bit about our family court. We have 38 elected judges in the whole court, but 14 here just the family, juvenile, and some criminal DV cases. That's 10 judges, 4 referees. And then we do have a one family, one judge policy. So after a judge hears a case for an hour or more, all the current and new cases regarding that family go to the judge.
Right, and that is a very strong policy in our court that we've had for over 2 decades. It lends to having a pretty familiar relationship with the parties, there can be downsides, but it really is one of the prime imperatives about how we docket matters and the familiarity that we have for litigants who appear in front of us. And that theme, I think, will come up at a couple other points.
Which does lead to, though, having some really busy dockets with intricate rotations and oftentimes booked several months in advance, which I'm not sure is much different than most jurisdictions, but definitely something we notice here. And then as Judge McKnight mentioned, Multnomah County does have a multi-decade history since the mid-'80s of community collaboration related to issues of domestic violence and often having a leadership role. And then just a little bit about Multnomah County and our population. You can see the numbers on the screen, definitely the largest county population-wise in Oregon. Demographics, 71% non-Hispanic white, 6% Black or African American, 1.5 American Indian Alaska Native, 7% Asian, 11% folks Hispanic or Latino as determined by the census. And, you know, there's been some reports recently in the last few years about communities of color and the impact that they experience in Multnomah County, and that often suffer more than similar communities of color nationally as far as having a sort of disproportionate hit, so to speak, additional loss of income for communities of color living in the county. Then they estimate the average about $8,000 per year. And then living in this area definitely enhances income for white people as opposed to other areas. So we just like to mention that because we're definitely keeping that in mind when we're looking at disparities in the court process and access, because it's definitely a conversation that we've been having in our community for the last few years. And then our team, we have our core management team, which is part of the Family Court Enhancement Project structure. Judge McKnight, our chief family law judge, myself as the coordinator. We have nonprofit domestic violence services, our family court services that do mediation and parent ed classes, juvenile court improvement coordinator, the domestic violence coordinator for the Multnomah County, our research assistants from Portland State University, and a couple of attorneys from the Oregon Law Center and legal aid, a private practice custody evaluator, our supervised visitation program supervisor, and then the director of the Gateway Center.
And the Gateway Center is a one-stop community center for survivors of domestic violence. And I think it's notable that all of the people on our management team are probably on at least 2 other non-grant DV committees, just in terms of how much is going on in our community and state. So we're all people who pretty much know each other very well and have been dealing with each other on domestic violence issues for quite a while.
And then our collaborative work group, we pulled from the Family Violence Coordinating Council, which is an organization in Multnomah County that was started in the 80s.
1987
with early court participation. And then this is a larger group including the district attorney's office, other nonprofit domestic violence services providers, culturally specific nonprofit domestic and sexual violence service providers, batterers intervention, CASAs, therapists, mediators, more attorneys, parole and probation, Department of Human Services, that includes our child welfare, law enforcement, etc. So we were pulling from a pretty large collaborative work group when we started that planning, as Amanda pointed out in her overview. So some of our challenges, and again, I'm sure this isn't too surprising for many jurisdictions, but we definitely have limited resources as far as money and time goes. The court in Oregon is definitely still recovering from budget cuts, and there's just a lack of time really to dedicate to extras. A lot of staffing levels are pretty low. And
on that issue about judges, you can see on your screen, judges feeling overly focused on DV, some of them. We've had, as I've indicated, such a long and strong history on domestic violence. There are so many training events, so many committees, and so much emphasis and so much product that some judges, and this is not everyone, but some feel sort of all right already on DV. You know, I've got it. I went to a counsel training. I've done this. I get it. I do the work. Let's focus on something else instead of domestic violence again. And that isn't the dominant view, but as courts become more aware of the complexity, I think it is harder to keep circling back to pick up new judges and new staff while one continues to refine and move an agenda forward. And it's a delicate balancing, I think, between, yes, we know you understand basic DV 101, but let's talk about it in a particular context. How does this play out for a litigant in this scenario? And trying to make it concrete and incorporate it into day-to-day practice. That's really a challenge for judges who think they went to a training or a couple of trainings and now they don't need anything else.
And that's definitely spilled over into the larger community. I mean, some feedback that we've already received from professionals that have been doing a fair amount of DV cases, for example, attorneys, definitely having some of that feeling of, oh, it's domestic violence again. We've talked about this a lot. So as you'll hear later when we talk about some of our activities, we're trying to think of ways to engage professionals that either aren't normally part of the domestic violence conversations or that maybe think we've talked about this enough. So just trying to get some creative ways to think about engaging those folks, getting buy-in. So some of our strategies when we first started with the project has been to create subcommittees with diverse membership to address the problem areas. And as Judge McKnight was saying, most of the management team members are 1 to 2 of these subcommittees. In the areas that we are focusing on and that we have committees have been the assistance to self-represented litigants, tools and standards, training, procedural fairness, and a survivor advisory committee. We've been really trying to strategize with court administrators to best utilize time because we also didn't want to leave out court personnel in our planning and training that we've been doing in this project. Oftentimes we've been having these larger conversations in the community, but the folks in the family law office, for example, that are doing a lot of restraining order work and working with domestic violence related issues haven't been to trainings and part of the conversation. We invited private practitioners to the management team and subcommittees, and then looking at ways to provide constructive feedback to judges and courts, and we'll talk a little bit more about that, and then just actively engaging other professionals that might not be doing a lot of domestic violence specific work, but definitely can be part of the conversations.
And one of the things on sort of the private bar issue I've noticed, I come from to the bench, and I've been on about 14 years, but this was after 22 years with one law firm, which was Legal Aid. And so we have a very strong awareness and presence by Legal Aid and its non-LSC funded sister, the Oregon Law Center, a very strong core group of private attorney, well, not private, of the bar who deals with that. But one of the areas I realize in retrospect, because the legal aid presence was so strong, we really had not, as a community, brought private attorneys who are not with legal aid, that is, actual private attorneys up to speed. And I think that's been one of the benefits in our committee work.
So in our planning phase, the planning phase activities that we had that were in later summer and later 2014, we identified our problem areas with the assistance of our technical assistance team and the collaborative work group. And we identified these problem areas and then try to identify activities to solve the problems and look at what our desired outcomes will be from these activities. And then I was hired in November of 2014. And then during that time, we also conducted a lot of survivor-focused groups. These were, well, to date we've had 5 focus groups. One with the Healing Roots Center, which serves African and African American survivors. El Programa Hispano, which is a project of Catholic Charities that serves Spanish-speaking survivors, and that group was conducted in Spanish. We had a group with Russian Oregon Social Services. They provide DV services to Russian-speaking survivors, and that group was also was conducted in Russian. Immigrant and Refugee Community Organization, they have a DV services for immigrants and refugees from all over the world. And then the Gateway Center for Domestic Violence Services. And then we had additional outreach to Native American and LGBTQ populations that have yielded some one-on-one interviews. And then in addition to the group, obviously we've done some one-on-one interviews. And we outreach to the community partners, really looking for folks that have identified as survivors and had some sort of custody case in the last 3 to 5 years. We didn't want their experience to be so far back that it wasn't relevant to current issues, but enough distance that they didn't have a current active case and felt like they could really talk frankly about their experiences in the system.
And this is against a backdrop of a court that has not historically had any mechanisms for seeking input. We have participation by the court on various community groups, as Jenny was saying, and one hears, anecdotally something in passing, but there really hasn't been a concerted effort to try to get direct information from litigants about their experiences in the court, much less in a domestic violence context. So that was, I think, one of the really valuable first steps that we took.
And we just used this graphic when we had held the focus groups just to sort of give folks an idea of what we're talking about with the family court system. So in our focus groups, we had feedback from all of these areas, and just depending on who was talking, some folks had very little to say about the judge in the case, for example, but they were really impacted by their experiences with court staff, for example. When we did the groups with the Russian and Spanish-speaking Spanish-speaking folks, and then the immigrant and refugee community, a lot of comments came about interpreters. So, different things were focused on it by different people. But the prompts that we started with, just picking a couple things on this system, let's talk about them. What were your experience as someone who's dealing with domestic violence, and what worked well and what didn't work well? And then what advice do you have for the folks on this list, and what can they do to improve services for other women dealing with domestic violence? And then is there anything else that you'd like to talk about? And what we got from our feedback from these focus groups is that we were right on with our problem areas and what we had identified as with our collaborative work group. So the problem areas, this is kind of lengthy, but this is sort of our official statement about our 3 problem areas. And the first one is basically that folks that are self-represented don't have a lot of resources and are struggling sometimes in the family court system when trying to move their case through. That oftentimes custody and parenting time decisions are not really thinking about or recognize the implications of domestic violence and how it's impacted the family. And then the last one is our procedural fairness area, basically that litigants aren't feeling like they're understood, respected, that they were treated fairly, that they were able to really bring their problems before the court and have a voice and talk about what happened. And this is also, we just want to increase the community perceptions and about the court.
So it sort of boils down into this idea of making sure, first of all, that survivors have information that's understandable and accessible, and others who help survivors have that. And then the second arena is really focused on those who are assisting survivors and perpetrators, do they have tools and mechanisms that can help them identify, prepare, and present information, and to assess information, whether evaluators or mediators or others. And then the third piece is sort of regardless of the substantive outcome, did the litigants, did the survivors and the other parties in the case, did they feel as if they were treated respectfully, that they understood what the decision was, that they did have a chance to be heard, and did they feel safe in the process? So it kind of boils down to those 3 major tenets.
And then that's how we identified our work groups and our subcommittees. So we're just going to talk a little bit about those subcommittees and some of the tasks and activities that they've been working on. So along the lines of trying to assist the self-represented litigants, we decided to create a position, we're calling it the court navigator, as a way to help self-represented litigants with DV issues navigate their family law case by helping them with things like starting the case, explaining the process, preparing for court, things that they might need to bring for court, and where's child care and things like that. And then just help issue spot when maybe they've stalled in their family law cases. So for example, maybe they haven't moved forward, but they thought this form was complete when actually the court's waiting on them to complete it, or maybe they haven't completed their parent education class that's required before they move forward, just different things like that. And then also working with folks to create safety-focused parenting plans.
And for me, as the judge, the emphasis is really, I keep saying upstream, upstream, upstream. I see so often, since I'm responsible for the daily assignment of cases, individuals who come to court that haven't completed required procedural steps in terms of if it is a case where mediation is required, or whether that's been done or there's been a waiver, which is obviously the usual practice in a case involving domestic violence. But we have a parent education requirement. Lots of times I see there hasn't been proof of service done on the other side, and litigants and survivors have taken time off work, made child care arrangements. They're coming to court expecting something to happen when in effect a lot of legal requirements or even regulatory rule requirements haven't been done ahead of time. And so part of this goal is to try to intercede earlier in the process as individuals are encountering and going through the system to make sure they stay in that legal boat as they go down the river there at the courthouse.
And we did hire a court navigator. Unfortunately, she left after a couple of months for sort of unrelated reasons to the position.
We've hired?
But we're almost hiring a second one, hopefully any minute. And one of the lessons we learned early on is trying to identify litigants to work with. And our original idea was that we would find litigants that had a contested divorce or custody case, divorce with children or a child custody case, and had some sort of protective order or a criminal domestic violence case, and started doing some outreach to those folks. Folks were interested in talking to the navigator, so she definitely the original person had a slow start, so we've been working to just look at other strategies to find litigants, doing some more outreach, looking at places where they can refer litigants to the court. We originally started small, with the funnel pretty small, because we just didn't really know how many people to expect that would be interested in these types of services. So,
and I think that lesson for us really reflects the range of readiness that exists in terms of any domestic violence survivor, and where sort of proceeding on a particular legal claim is in comparison to anything else going on in that person's life, whether it's housing or support or anything else. And being open to being contacted, but probably also, I think, needing to rely on referrals for people who have been identified as ready. So a combination of here our door is open and you're in the pool, but also getting referrals from individuals who've identified people who are wanting the kind of assistance, the upstream assistance that a navigator can provide.
Yeah. And the other thing that we've been talking a lot about with our self-represented litigants is that we just don't have a lot of materials, tools, things accessible to litigants about how to move through the process. Even a lot of the self-help materials we have are still at a really high reading level, just not good plain language principles, and still hard for litigants to understand. For example, the divorce packet comes with about 10 pages of instructions that mostly people don't read, and even if they do read, it's still pretty confusing. So we've just been looking at ways to make one-page guides, info sheets that we can have on the court's website and have in hard copy for litigants to look at to help them through specific topics. And then the other thing that we're interested in doing are creating some short instructional videos for the court's websites and setting up some places in the courthouse that they could be watched by litigants that have some questions and want some more information that maybe they can't have the one-on-one assistance. So we have started doing sort of a larger document that we're calling for now steps for completing a divorce or custody case. One-page info sheet about fee waivers and deferrals. Again, a pretty confusing process for folks. We have a list of additional topics to create guides that we've gathered from the focus groups, ideas that we've gathered from focus groups, the staff in the family law office, advocates that are hearing what folks are struggling with. Also a list of desired video topics. And then we've been looking at a local grants program that provides grants for technology-related items to look at leveraging the investment with the Family Court Enhancement Project grant to be able to do more in the video arena at once. And then there's also been some interest in from the Oregon New Lawyers Division, from the Oregon State Bar. They've been interested, it sounds like, in creating some videos as well. So we're going to try to work together and see what we can create.
And as a state, Oregon is in a transition phase at this point, coinciding with our Family Court Enhancement Project grant. But the transition that we're in is moving from having model forms for most family law matters available online with separate wordy non-plain English instructions to interactive forms. They're in development, and some of the early ones should be available soon. We do have interactive forms for restraining orders, but not for other cases. And trying to sort of play where the ball's going, or the puck's going to be, in the old Wayne Gretzky saying, I think that the use of a basic handout that describes in general terms some aspects of legal process in a divorce or custody case, but also the videos in particular that aren't dependent on particular forms, but that explain discrete types of topics that come up in a case, whether it's service or parenting plan or moving or exhibits in court that people can choose to listen to a short video. Those have value independent of how interactive forms are instructed, and I think for the types of people who, like myself, are visual learners and can sort of watch something as opposed to read something, we're hopeful we have a product that survives the grant. So the other main area is one that I'm probably, this is Judge McKnight again, probably the most closely involved in, and that is this problem area of ensuring respect. It's got the bullet name of procedural fairness or procedural justice. I've been the chief judge for almost 4 years, and I shouldn't say I'm surprised at the letters that I get. I do get a regular run of letters, and it's mostly, can you get me a different judge? This judge isn't being fair and isn't listening and yada, yada, yada. And I don't have that power. If you're the judge, you're the judge, and the person has to appeal the particular decision. But in listening to some of the audio records from hearings, which I do occasionally as the chief judge to try to write a responsive letter back to the person, it became clear that our judges are not always able to be as mindful as they should be of the interpersonal dynamics when we're in court. And as we said at the outset, and I know every family court is busy, but all of us feel incredibly busy. We are booked 4 months out. We don't have any holes in our dockets unless a case schedules, or unless a case settles. So we're always, or settles the day of or the day before. So we're always feeling that we don't have enough time really to do what we want. And I think that pressure is one of the factors that plays out in the courtroom in terms of how some of us may be dealing with litigants. I think there are other factors of simply flat-out ignorance in not perceiving how something we say is being felt or heard by the other party, and issues as well of not understanding the impact of trauma on litigants, particularly domestic violence survivors, and why testimony might be inconsistent or not linear or not as well prepared, and perhaps the litigant is more emotional. So we've really tried to brainstorm around these issues. And one of the sort of the preparatory things we did was solicit information from our management team and from others of cases that those in the field thought were problematic or laudable, good or bad, in terms of how there was a judicial interaction of some type. And Jenny listened to quite a few audio records of hearings and kept a summary of some verbatim statements and interactions, things that were pretty problematic and things that were really positive and good ways of relaying a message or other practice that happened in court. And we've combined them, and we have given the judges a hard copy of them, and we'll be using them with our consultants on this grant in a debriefing where we kind of go through and talk about the particular comments. We've also, I've been talking to the judges about various ways that they might be interested in receiving feedback, whether it is videotaping them with knowledge of the litigants or listening to certain audio records from hearings they've done, or perhaps having a peer, one of their colleagues sitting in, or even one of the consultants, or even someone who is expert in body language and communications to comment after observing how body language, eye contact, and that sort of issue is being perceived there in the courtroom. So this is sort of, we're beginning that process here and hoping to have, I think we're moving our February session to March, as I recall, with the individual judges about proceeding on how they themselves want to go on their own individual basis. But we also wanted to make sure that we had a baseline survey, or a baseline figure, I should say, of where we were on sort of procedural fairness responses as a whole. And the next thing on your screen is sort of a screenshot or a cutout from that survey, asking, we did this for a week, every single person in the courthouse. We haven't had a survey like this ever in the 14 years I've been here. But really asking, the top part you can see is whether people were respectful to the person who filled it out, whether court staff explained things in ways they could understand, whether when that person left they understood what the next steps were, and whether they feel safe, whether they felt safe in the courthouse. And then the bottom half is if someone was actually in a court hearing, whether the judge explained how the proceeding would go, the judge appeared to be listening when the person was speaking, if the litigant felt they were able to share information, or if the judge explained why the information couldn't come in, they felt the judge was neutral in conducting the hearing and they understood the judge's hearing, the judge explained the reasons, and they felt respectful. We did have a section that you don't have that has the litigant or the respondent in the survey fill out who they were. Were they a party in a case, a lawyer in a case, maybe a support advocate, maybe a juror, maybe a witness, maybe someone who just came to get copies of court papers, whatever it was. So we're just in the process of trying to collate this information. I think we have one view right now, and that probably the individuals who dealt with our family court had a somewhat less positive interaction than with criminal court, and I'm trying to think through that, certainly they don't have lawyers in 86% of the family law cases, and that really does mean that litigants and domestic violence survivors are going to be needier than criminal defendants are in terms of what they need from the court because they don't have attorneys. So I don't know that that's the answer, but it's one of the things that occurs to me in the type of parsing and discussion that we'll have as a group as this survey proceeds. And at the end of the grant, when we do a second baseline, we'll have a way to see if additional training, because as this slide that you're looking at now here, we're going to be doing more training with staff and more training with judges and have individual conversations. We'll be able to see if there is a difference in the kinds of feedback that we're getting when we do a second line on that. And we did training with court staff on trauma, and I think you're going to, yeah, Jenny's going to talk about that. One of the main pushes that we recognized in preparing for this grant was court staff, even though with the budget cuts, judges had continued to get training opportunities, court staff had been left in the dust in terms of nothing for quite a long time. So that was really a priority.
And the other thing about the nice thing about the survey is that we sort of pushed this through, and I think definitely we'll be able to alleviate a lot of fear from court staff and those involved. I think there was a lot of concerns initially that only angry people will complain, and we're talking about criminals, and that it's just going to be horrible results. And we're seeing that, folks, as we know about procedural fairness and procedural justice research, that folks can really identify between the outcome of their case and how they were treated. And so we've been able to, I think we'll be able to sort of talk more openly with court staff and judges about what it might look like to have ongoing ways for litigants to provide feedback. And also one thing I wanted to mention, talking about the body language experts, communication folks, observing judges. We actually stole that idea from, I think, Hennepin County. So that's been one really nice thing, just a plug about this project and our technical assistance, is that the coordinators have been interacting, and we've definitely been able to brainstorm a lot together. So that's been really positive about this project. And definitely, if folks have questions, feel free to chat. I know chat us. I know we're talking quite a bit here, but we can stop for questions. Our third committee area, problem area, we've been calling tools and standards. Really, this is that area of getting other family law professionals, and by that we mean mediators, custody evaluators, parenting time coordinators, attorneys, just some guidelines for screening. We researched a lot of existing tools and made a plan for selecting and creating a tool. This has really gone back and forth quite a bit between, do we need a specific tool? Do we need to have guidelines for them on how to pick the tool? One thing that it kept coming back to is that we really need to train professionals about domestic violence. And as we spoke earlier, that same issue of no one wants to come to domestic violence training because they think they know all they need to know about it. We administered a survey to these family law professionals, and are hosting a couple of focus groups for attorneys to try to get their input about their experiences working with families in DV, and then what kind of training and things that they might want in the future around domestic violence and perhaps using some tools. In the survey that we did to the professionals, for example, one of the things that came back was a lot of people selected, I'm really competent in my knowledge about domestic violence. But then when you ask them where they got their training, there's like, I've had some, DV cases before and things like that. So again, trying to figure out how to bridge that gap between, I know everything, but I'm going to accept some training on whatever issue that we're talking about. So for example, maybe it's going to be how to create better parenting plans, and then we can talk about domestic violence when we're doing that. And that kind of leads into the training piece. All of our problem areas that we identified have some aspect of training. So we wanted to make sure that we weren't leaving court staff out, as Judge McKnight said. So we wanted to have basic trauma training and domestic violence training and procedural fairness training for court staff, and that's been a little bit easier to coordinate in some ways. We have a little bit more control, and we wanted to have some discussions with judicial officers about feedback from those court recordings focus groups, train domestic violence advocates about the family law process and how they can support survivors they're working with, and then creating a multidisciplinary training about the implications of domestic violence on children and creating safe parenting plans, again, as a way to have a deeper conversation about domestic violence and maybe look at what kind of tools family law professionals could be using for screening. So far the court's hosted 4 two-hour trainings. They've all had the same content on a basics of trauma-informed care. We had 62 family law clerks, judicial assistants, judicial clerks, interpreters, even some IT staff attend these trainings. Robin and Amanda, 2 of our technical assistants providers, they facilitated 2 sessions of comings and goings, which is an interactive sort of in-her-shoes style domestic violence training to family law staff. And we ended up doing that partly motivated by the manager in the family law office who had attended our first all-sites meeting in Minneapolis earlier this year. And she participated in the training there, and she was so moved by it that she really wanted us to be able to do it for all of the family law office. So it's really been important, I think, including court staff, and we've gotten really good feedback, which we'll talk about in a minute. So that's been really encouraging. And then I did a training for advocates and social service providers about a basic of court processes, and then we have that procedural fairness training scheduled and some other, creating a training plan for other training needs that we've already identified. And there's some comments from some of our trainings so far. Most of the participants have found it useful and found ways that they can identify to incorporate the information that they've learned into their work. Some of the comments, good to see more of the challenges people face before coming to court, thinking about how early childhood trauma can so drastically affect adult life, and better ways to think about this when dealing with an ornery adult. Excuse my typo there. It was very informative, and it stuck with me through the weekend. I've been thinking about ways I can personally help others to improve my skills. So you can kind of see where court staff were at, I think, with some of these training and domestic violence issues. And then again, just anecdotally, we've gotten a lot of feedback of just that they've been thinking about it a lot and thought of ways that they can improve their customer service working with litigants.
Right. I think there's been some synergy with the domestic violence focus, leveraging some interest separate from trial court management to improve customer service. And I hear phones being answered differently. How can I help you? Which I didn't used to hear, even when, there's a general number called. So I think we're actually getting some traction in that arena.
And that's been the one nice thing about this grant, and having the coordinator, myself, be able to spend some time finding out what other folks are doing in our community and seeing if there are ways that we can sort of leverage what other projects are doing or their other interests, like this customer service piece with court staff. And then, as we said earlier, the courts have a long history of and dedication to domestic violence work and community partnerships. We know procedural fairness right now is sort of a hot issue. The mental health court and the mental health court improvement coordinator with the county, they have some grants specifically looking at trauma-informed care for courts. The Multnomah County Court received a grant from the Center for Court Innovation to develop procedural fairness in the criminal court. Juvenile court's been looking at trauma-informed care for a while. Our Safety First Supervised Parenting Program has a training component as well. And then there have just been some statewide efforts to improve the website and the materials accessibility. So just trying to make those connections and see what we can do together.
Yeah, I think it's been sort of fortuitous that there are other parallel initiatives that are helping reinforce some of our own grant purposes. But ideally, we want a project that has some sustenance, some maintaining, and some life, some institutionalization when the grant money is no longer with us. And maybe I'll let Jenny should just talk about the vision first, because I'm jumping to the last point there. Sorry.
Well, no, it's okay. But just, I mean, as with the Family Court Enhancement Project in general, and probably as you've gathered as we've been talking about our activities, but really our vision is that children have appropriate and safe visitation with the abusive parent when, again, when appropriate, that litigants feel comfortable using family court and recommending it to others as a solution that has worked for them and not something that's negatively impacted their family or their safety, and that family law professionals in the courts can confidently talk about domestic violence instead of ignoring it, sweeping it under the rug, and then, as Judge was saying, looking at those institutional approaches.
But I think with any grant project, there's always a tendency to have a flurry of activity, and then 3 years or 5 years later, people go, oh yeah, I think we did something like this when we had this grant, but you know, I think I might have a memo or something around on that. And for me, the real job is to try to go to enough to the core of what we're doing that there is some semblance of cultural and institutional change. And in the procedural fairness arena, for example, having the idea of feedback and a way to provide feedback become a culture in our court instead of just something we did twice during a grant period. And the same thing for information, that we have a regular review of information, not just when law changes, but that we're looking repeatedly through a lens of is this understandable and accessible, you know, to domestic violence survivors. And the same with the tools. And when you're as old as I am, and I'm 62, you find out that you keep pushing forward and you forget to go back and bring the new people forward. And we've had we've had a judge change just in the last month, and where one judge retired and another judge came on, and it was just an occasion for me to realize I can't start at the current spot. I have to go back and sort of bring the person up to speed to where we are. And those who have been in the domestic violence field for some time, and I'm speaking of myself, I forget to do that, and having systems that that are set up to regularly, annually, and repeatedly bring the same messages forward in a consistent way, I think that's how we bring people along instead of just, oh yeah, we did this once on a grant. So Jenny and I have talked an awful lot, but don't know if any of you had any questions about anything that we're doing or why, or any barriers or problems or anything on the success side. So I guess we'll pause and see if there are any. So how would we know if there are, Jenny?
Well, I think people can maybe talk through or the chat box.
Okay. So I'm not seeing that there are. So Amanda, what would you like to do?
Oh, I guess one quick thing I can do is give a plug for the next webinar session, which will be from Cook County, Chicago, on December 2nd. So I'd like to hear, Cook will be a little bit different because they're a different division of their court, so it would be a little different emphasis. And then just generally, maybe if folks have some ideas of if there's anything that they've tried in their jurisdictions that they'd like to suggest or, you know, put out there as something that they've tried.
It's always hard on a webinar to be the one to jump in. Well, maybe just to close out, Jenny, what's been the most surprising thing to you, do you think, on this? And then I'll tell you what mine is, you know, roughly a year in.
The most surprising thing. I think I've been associated with the courts for a number of years in a different capacity. I was an advocate doing legal advocacy work, so I was actually fairly close to a lot of the folks in this project and the court staff. And I think one of the surprising things, pleasantly surprised, is the eagerness of a lot of court staff, and particularly the family law office, at talking about these issues and just sort of embracing these concepts and thinking about trauma and domestic violence and supporting litigants in a different way. That's been a really nice part of this work, I have to say.
And, you know, that's ironic that that's the surprising part, because it might have a very similar reaction. We tend to think in family court about what the judge does, and I'm not saying that what the judge does isn't important, but so many people actually don't have hearings, or they have short hearings, and they have more interaction and earlier and higher need with court staff. And I think not paying attention to that and not realizing that earlier, I think we sort of dug ourselves a fairness hole that we didn't need to by, as a state, not prioritizing court training and court information about these things. So I think it's not to diminish the importance of a judge's actual ruling and the in-person hearing. That's not the end and be-all in an encounter in family court. And what's on the web, what's said at the counter, what's said by the judge's staff, I mean, all of that is just as important, and sometimes more so, than what happens in the courtroom. So sort of the breadth of the experience is my kind of major takeaway. But I think we are out of time, if I'm looking at my clock correctly, Amanda. So maybe we'll just wrap it up.
Yep. I'd like to thank everyone for coming. We really appreciate your participation. As I said at the beginning, there'll be a survey that pop up, so please stay on. Alternatively, you can click the SurveyMonkey link there. Thank you, our presenters, Judge McKnight and Jenny. We really appreciate your time this afternoon. And please join us for the next webinar on December 2nd. Thank you.
All right, bye-bye.
Thank you.